Here's a question most people don't ask until it's too late. If something were to happen to you tomorrow, would your spouse and your kids be on the same page? Not emotionally, but legally. Here's what I mean by that. If you have a blended family and you don't have an estate plan, the law will treat them as categories. It's not going to be based on fairness or what you would have wanted. There's Colorado laws of intestacy that would come into play in a process that we call probate to determine who gets what. I've sat across multiple families where they tell me that they don't think it's fair. But the truth is that the law is not about fairness. It's about looking at the situation and filling in the gaps with the default laws. So today I want to talk about what happens with blended families, because it's hard enough for non-blended families to go through probate. But if you have kids from different marriages and you've been remarried, then not having an estate plan is extremely important. We're going to talk about why that happens and how families lose trust in the probate process. Think about it. Two families merge, two sets of kids, two histories, two homes, multiple assets. Everyone says we're family now, everybody gets along pretty well, but life moves on fast. And sometimes you don't get a chance to update beneficiary designation. Look at the joint ownership now that you bought a new home with your spouse, or review the old will that said I want everything to go to my kids. Imagine what happens in probate with all of these unupdated scenarios. If they look at the life insurance and you still have your ex-spouse listed as the beneficiary on that life insurance will not go to your new spouse or the kids. They look at joint ownership and they see that your new spouse is actually a co-owner of your new house and you've put all of your retirement savings into that home. Your will says I want half of that home to go to my kids, but because your new spouse is a joint owner, he or she is going to get the house and not the kids. That's why it's essential to update it. Colorado law does not ask who loved who or who promised whom, whatever. It's all about what the paper says, that you left a valid will or a valid trust, or how your accounts are actually owned and titled. The law doesn't get caught up with all of the changes unless you keep caught up with all of that. So how do we fix it? Let's start with one simple question. Does my plan still match my life? If the answer is no, or I don't know, I need to get it reviewed, you need to come see us today. Because again, it's not just about a basic will that says I want everything to go to my kids. It's about making sure we look at everything that you own, how you own it, and then incorporate it into a plan that's designed to avoid probate, years of litigation, and most importantly, your family losing trust for each other. This is something that I leave you with to think about. If you have a blended family, is it important for you to make sure that they don't get completely torn apart if something were to happen to you? Do you care enough to make sure that you lay out specific wishes? Then you need to come talk to us today. And let's face these realities together and create a valid plan under Colorado law so that you know that you're going to live up to the promise of I took care of it when the time comes.